Hello, everyone, and welcome to Internet Law Review. So, we will recall the time that fellow attorney Legal Eagle did a review of a deleted scene from Captain Marvel and concluded that Captain Marvel was not the villain when she crushed a guy's hand and stole his motorcycle and his jacket. As we can see from the vote ratio, 8.4 thousand votes up and 10,000 votes down, this did not go over very well with the community at large. First of all, Mr. Eagle says some of us have strong feelings about a fictional superhero. Now, I'd be slightly remiss if I didn't point out that this is a logical fallacy, because someone's feelings about a fictional superhero does not go to the merits of the argument. Attacking someone because of their supposed allegiance to a superhero is attacking the character of a person rather than attacking the argument. So, Mr. Eagle begins off with an informal logical fallacy that should offend us all. But putting aside that issue for the moment, let's respond to the first substantive argument. Mr. Eagle says, grabbing a map isn't harmful, probably true, by amicably arguing the offensive touching point, that the motorcycle guy committed battery should be pretty uncontroversial among lawyers. Well, right away I'd have to disagree with him because I am a lawyer and I think it's extremely controversial. Mr. Eagle also says famous cases of offensive touching include snatching a plate out of someone's hand and taking a necklace off of someone. So not really a stretch to extend those cases to what happens here. Reasonable minds can differ though. So first, let us remind ourselves with what the Don actually did that Mr. Eagle says is the offense of battery.
How about a smile for me, huh?
Yes, so it is this small gesture from the Don that Mr. Eagle says qualifies as battery, and what's more, says should be uncontroversial as to that conclusion among lawyers. Mr. Eagle, in his video review, gives another example of something he considers to be battery.
So, for example, if someone was walking down the street and they were holding a cell phone in their hand, if you went up to that person and smacked the cell phone right out of their hand, well, even if you don't actually make contact with the person's hand or their forearm, the fact that they were holding the cell phone and it fell out of their hand, that's enough to qualify as battery for the person.
So based on the video and based on the text comment, we now have 4 different things that we can compare and contrast. According to the text, we have the example of snatching a plate out of someone's hand. We have the example of taking a necklace off of someone. And then based on the video, we have the example of smacking a cell phone out of someone's hand. And we also have the example of slightly pulling a map out of the way in order to get it out of their line of sight. Mr. Eagle says that these 4 things are of a similar kind, and so it's not a stretch to extend the first 3 things to the 4th thing of pulling the map out of the way. As to that argument, I have but one bit of substantive legal reply.
One of these things is not like the others. One of these things doesn't belong. Can you tell which thing is not like the other by the time I finish this song?